becomes the guardian of your children. The second option, or the second option to be a guardian, would only become a guardian if the first option passes away or decides that he doesn't want that role. Now, of course, in many situations, there's a household that only has one parent, and it's very important for that one parent to have this guardianship clause, because what happens is if he passes away and there are children under the age of 18, then the government of Alberta could step in and make sure that somebody is taking care of these children. Of course, it's a case-by-case scenario. We never know exactly what's going to happen, but why leave it to the government to decide on who is going to be the guardian of your children? Maybe before I lead on to the next topic, if anybody has any questions in regards to the main focus of the will and the guardianship clause of the will.
Anyone have any questions, brother? طيب, for me, I just have, so regarding the property here and overseas, he should mention overseas and here as well in that will?
Now, what we do is a very generic will. So it mentions your whole estate as one. And we don't mention specific properties. Reason being is that property could be sold, could be transferred to somebody else. Anything could happen to your property, whether it's a bank account, a property, an investment. But yes, you can mention property that you own, for example, in Egypt, just so your personal representative knows there is property there. However, a lot of people would just tell their personal representative, hey, I have a bank account in this country, or I have a house in this country. And then that personal representative can make sure your will is sent over to that country. And inshallah, again, it's going to depend on the country, because every country has different rules, but they can execute your will there according to how you wanted it to be. Yes, brother.
As we are living here and our brother sister lives in other country, so they get some portion of my wealth here. So if we put their name here, so I don't know how to get that money access.
So the question from our brother here is, if your beneficiary, so the person that's inheriting you, is in another country and you live here, how are they going to get their portion? So that's the job of the personal representative. So the personal representative, when you pass away, he's going to either sell your property to get cash, or he's either going to take out the money from your bank accounts. So when he's done all of that, he's going to make sure that everybody, according to your will, has gotten their portion, whether they live here or whether they live overseas. He's going to make sure that they got their portion. Yes, brother.
Can be non-Canadian?
So the question is, can the guardian or the personal representative be somebody that's not in Canada? Am I correct?
He is in Canada, but he doesn't have a citizenship.
That's fine. So the question is, can the guardian or personal representative be somebody in Canada but does not have a citizenship? So that's fine. The only thing you have to worry about is there a potential that they may not be a permanent resident in Canada? And if it's for a guardian, it's going to depend on where you want your children to reside. Of course, it's going to affect that person. But as a personal representative, that person can be in Canada, and they should be in Canada. And if they have a passport, a PR, a citizen, it's not going to really affect anything, because they're going to make sure your will was executed to how you want, and then they can continue on with their lives. But you have to think about it more if they're a guardian, of course, because you want to ensure that maybe you want to keep your children here in Canada for the rest of their lives. Maybe the country that you're originally from isn't stable, or doesn't have an environment that you want your children to grow up in. So when you pick your guardian, you need to pick wisely, because their future is also going to depend on it.
That is not a concern. Then by law, that person, the guardian, I mean, can be a non-Canadian, right?
Can be a non-Canadian, right? Yeah, it can be a PR or... Yeah,
yes.
He just answered. It
Yeah,
can be a PR or...
Yeah, so like I said, The guardian can be a PR, can have a Canadian passport, but again, you need to think about, is that in my children's best interest? Maybe that person's not going to be in Canada forever, and if he's not, and I don't want to complicate this too much, but because other people can get involved. Let's say you have a cousin here or a brother or sister, and that person that you chose as a guardianship moves with those children and or wants to move outside this country, your brother or sister or relative can get involved through the court system and make sure that the children stay here. So you need to really think about who you want to pick as your guardian, and if it's in the best interest of your children, of course.
Yes, sir, Doctor. Please.
I have a question about the legal perspective. In order for a will to be recognized as a valid document legally, what needs to happen?
So the question is, in order for a will to be legally recognized as a valid document, what needs to happen? Now, in Canada, there's two different types of will: a formal will or a hologram will. A hologram will is when you do a will on your own and it is binding. The courts may listen to it. When your executor says, this person, the testator, wrote on the will, I want to divide my property according to A, B, C, the courts may recognize it, all right? But
May or may not, right?
that's correct. Every case is different. I don't know if that will, whoever writes the will is gonna write a proper will. I don't know if he's gonna write a legal will. The second option is the formal will. That's a will drafted by a lawyer. Now, the reason why it's beneficial for you and your beneficiaries, of course, is to go through a will drafted by a lawyer is because it's gonna have the debt clause, it's gonna have the tax clause, it's going to have the guardianship clause. It's going to have many clauses that's not going to be inserted when a will is drafted on your own and just given to somebody to make sure, hey, make sure this will is divided according to what I wrote here.
The purpose of my question was simply to make sure that I have been writing these wills for people for 30 years.
I'm sorry, what was that?
I've been writing these wills for people for 30 years.
Yes.
And it's written in a very legal language. It identifies who the will is for. It identifies when it is effective.
Yeah.
It identifies the two executors. If they are younger children, it identifies the guardians. It identifies if from 1/3 of his assets, if he wants to build some donations or whatever. And then it identifies who the beneficiary will be and their exact shares.
Yes.
And also has a clause at the end that says, if anything changes in terms of the addition or deletion of the beneficiaries, that clause number such and such has to be redone according to Islamic principles. So it has that clause at the end. And then it is signed in the presence of two witnesses and by the person whose will it is, and it is attested.
All right.
Would that be considered a valid document?
That's a will. That's a will. I'm not telling you that the court is going to accept it or denying it, but that's a will. Now, there's a case that came out of Saskatchewan. It's a very interesting case where, and I don't remember the exact facts, but to keep it broad, there was a farmer, I believe, he was stuck under a tractor and he had no will. So as he was dying for whatever reason, he wrote it in the tractor on the gas tank of what he wanted done specifically with some certain property, and the courts followed it. Now, the issue with that and the issue with wills not done by lawyers is there's a much higher chance that it's contested in court. Somebody else may come in and step forward and say, hey, the testator, so the person that died, the person that drafted the will, did not have the intentions of giving this person X amount, or he did not have the intentions of having this person as an executor. And that's and that's when a lot of issues come up, is the intentions of the person writing the will. Now, it's questioned more in court because it's not a formal will. But when it's a formal will done by counsel, so a lawyer, then the intentions are clear because he's gotten legal advice in regards to the will. And now, brother, if you want to discuss more about.
Just a quick question. So even if a will was done by a lawyer and the beneficiaries and their shares were identified according to Islam, as all done legally, any one of those beneficiaries could go to court and say, I don't agree with this Islamic law, I want to apply the local law. What happens then?
So again, that's a very broad question. The question is if one of the children, after the testator has passed away, has said, I don't agree with Islamic law and I don't want the testator's estate to be divided that way. Now, I can't answer that question. Every single case is different. It depends how many children he has. It depends on maybe one of the children is the one that built up his dad's business and he's saying, why do I get the same as my brother who's never been involved in a business, right? So there's situations like that. That's a very broad question where I can't say yes or no.
What I'm asking is that, would the court say if the Islamic law is contested, that the law of the land must apply?
Sorry, what was that, brother?
If the Islamic law is contested by any of the people,
Yes.
that therefore now it is going to automatically go to the law of the land.
Now, in a lot of cases, yes, but however, they look at the intentions of the testator. And if it's clear that the intentions of the testator was to divide his estate according to Islamic law, the courts in most cases, in court or in whether in any type of law, you can never say 100% to anything. In life in general, you can't say 100% to anything. But in most cases, they're going to follow what the testator said in his will. And again, if it's drafted by a lawyer, the court's going to understand that that person got legal advice and that person knew exactly what he was doing. So they're going to, of course, listen to him more than if a third party comes in and says, hey, I don't want the will to be divided. I don't want that person's estate to be divided that way. Jazakallah khair.
Just there is a question on Facebook. Sayyid Khubayb Ashir. He said, in case of a tester's death, children under 18 would be taken care of by the appointed person. What if we don't have any relative, friends? How do we make sure kids are taken care by Muslim family?
So of course, that's why you would draft the will. Now, in that question, when they say appointed person, I'm guessing they mean the guardian that they chose or the personal representative, and I'll answer it both ways. So of course, if they mean appointed person, then that person that you chose to be a guardian will be the guardian of your children. And nobody can really interfere with that unless, again, a relative or family friend goes to the surrogate court. So the surrogate court is the court system that takes care of estates. And they say, no, we don't want that person to be a guardian. And they state their reasons, right? And then in every case, it's going to be different. Now, here, if they mean the personal representative as a person that's appointed, then that will was not drafted properly because there is no guardianship clause. Now, you need to ensure that, let's say you draft the will right now and you have no children. Once you do get children, you need to make sure that you either draft a new will or you add a codicil. A codicil is a piece of paper on the back of your will saying that I'm changing clause A to say this, or I'm adding a clause. And that clause could be the guardianship clause. So you always have to do that once a huge change has happened in your life.
Brother Muhammad, what happens in Alberta if a person dies and he doesn't have a will at all?
So when a person dies, there's two different ways it can go. If a person has a will, it's called a grant of probate. So the question for everybody at home is what happens to the testator or somebody that dies in Alberta that doesn't have a will? And there's, like I said, there's two ways of going about it. The first is if he has a will, your personal representative will need to apply to court to get a court order to sell your property and divide it according to the will, or to do transfer of land in regards to, transferring certain property to make sure everybody got what they're Islamically entitled to. Now, if you die without a will, it's going to be called a grant of administration. And now that's why it's so important to have a will. What happens with that is anybody around you can apply for that. It could be your brother, it could be your sister, it could be your cousin, it could be your friend, somebody that's close to you. And they're going to need to go to an estate lawyer, and they're going to need to apply to the court to be the executor. All right? And then when they're the executor, they need to either provide evidence on how the estate should be divided according to what the testator wanted, or it's going to be divided according to Alberta law. But that's the scary thing about dying without a will, is anybody could be your executor, so your personal representative. It could be your friend, it could be somebody you don't like, it could be somebody you don't trust. And that's why it's important to have a will, so you can pick someone that you do trust.
There is Abu Omar.
Assalamu alaikum.
So, just a question. Who can I write the will to? Or can I, let's say, put it under anybody I choose? Or like the beneficiary?
The beneficiary.
Yeah.
So the beneficiary is the person that's inheriting you.
Exactly.
All right, so
Can I pick anyone I want? Or
so the question for everybody at home is, can you pick anyone you want as the beneficiary? And I think it depends if you want an Islamic will or a will under Alberta law.
say both, Islamically or Canadian law?
So Islamically, and I think I'll let Sheikh Mahmoud answer this one.
So in Islamically, of course, Allah subhanahu wa ta'ala divided equally. However, I think you missed the first workshop. So, but here, alhamdulillah, the will that we drafted, what you can sit with the brother Muhammad, inshallah, when you write it down, it is 100% Islamic what it's mentioned there. But if you said, can I give someone who's not inheritor, he's not a beneficiary, a brother, I have a kid and my brother is not going to have anything and he struggles in life, can I give him some money? You can donate up to 1/3 of your entire wealth. You can appoint that 1/3 to anyone poor, any organization, Islamic organization, anything. So you have only up to 1/3 to play with. The rest, it should be according to an Islamic.
So now the question is the Canadian way. You can give your estate to anybody you want. Legally, as long as you mention them in your will and you state, I'm going to divide my estate between 4 people, my 3 children and my wife, for example. All right, then it's going to be divided to how you want. But again, if you say, I want to give half of my estate to my wife and you have 3 children, and you say, I want to give the other half to my cousin, then your 3 children can apply to court and say, no, we're entitled to a portion of the estate. We're his children. And they'll get a portion of his estate. So here under Alberta law, you can't just ignore your children and not give them anything. It's kind of, in a sense, the same way as, of course, big differences, but...
Islamically, if I give half my wealth, let's say to my brother, and I forget about my kids.
So, Sheikh Mahmoud.
It has to be, you can give that during your life because it's your money, but you cannot put it in a will. If you put in a will and you say, I want, after my death, I want half my wealth to go to my brother, it's not Islamic really. But what it can be corrected. What is it can be corrected? You only give 1/3 and that's it.
But what is the punishment from Allah to me if I do that?
Fried in the hellfire, I guess. Allahu Akbar. He has a question. He has a question.
Can we learn the lesson and then later ask the question, because the lesson we learn become questions. We want to learn from him first, then ask question later.
Of course, brother.
Everything now change to question.
Of course, brother.
We want to learn when we sit here to learn.
Of course, brother. And I think there's benefits to both. When there's questions, people interact more and they listen more. When I talk for half an hour straight, I think people get pretty bored and they start walking out.
We're going to talk about the main points
Yes,
for the will, and that's what we're here to learn first.
of course.
Then we ask questions.
Of course. And I'm here as long as possible. So if maybe we take one more question and then we
And
can...
inshallah. So alhamdulillah, we're receiving a lot of online questions as well from the brothers over. So it's more when someone asking questions, that is almost a point that we will talk about. So bismillah, tafadhal.
It can be open questions. I was just wondering if you have a general for well, according to the follow, then you can, I'm sure everybody wants to modify it, you know, it depends on the situation and how many, the circumstances that you live in. But do you guys have a general form? For
It's already done.
Okay, that's.
Yeah.
Yes,
so-
it's already done. So the question for everybody at home is there a general will for everybody to follow or already prepared according to Islamic law? And that's what, when I was introducing myself, and maybe it wasn't a very good job, but we've already, myself and Sheikh Mahmoud, and mostly on Sheikh Mahmoud's part Islamically, he's prepared a very well done schedule of how your estate should be divided. And then of course everybody's situation at the time of their death is going to be different.
Like every situation you can imagine, it is there. Died, he only left 2 kids, 1 year. No kids, just parents. No kids, just brothers and sisters. Okay, brothers with kids, uncle, cousins. Almost any situation you can imagine. I even mentioned in a kalala, which a situation does not, I think, you know, maybe rare when it happens, if it happens, but I still put that in a well Islamically what it should be divided.
So is this the form that available in the Al-Rashid website you are talking about, or a different form that is developed?
No, it's not. It's not the same one as is there. So yeah, so it has this one. Alhamdulillah, it's again, it's reviewed by Alhamdulillah myself, a few scholars, Islamically done, and mashallah, brother Muhammad, he worked on it hours and hours to put it in a legal form. So all what a brother has to do, mashallah, is come, sit 20 minutes, 30 minutes, and inshallah sign and everything. He listen as well to him, and that's it.
Sheikh, cross question, sorry, I don't want to take that much, but it's just that if you have a will like this, you know, endorsed by a lawyer, that's a must by the court to be going through this. This is done in according to whatever we agreed on by a lawyer endorsed, so it should be
Honored by
So
court, of
honored.
course.
So the question is, if it's endorsed by a lawyer and you want it done according to Islamic law, the court is going to honor it. And my answer to you is inshallah yes, because I can never say 100% to everything because every situation is different. Again, as the example I gave previous is when you divide your estate, you're going to give, for example, both your sons equal parts. Now one son could say, and you own a business, let's say, one son could say, no, I built up that business with my dad. The other brother didn't do anything. And he can apply to the court and say, I get a portion of that business. Now, previously, Sheikh Mahmoud said, you would need to divide your estate prior to you passing away. Now, if you think it's fair that, and I think Sheikh Mahmoud should discuss that more, but if you think it's fair that your child should get the business, then you would do that before passing away.
No, jazakallah. So we have a question online. Are we allowed in will to mention that don't send our body to autopsy?
Yes, so it is actually mentioned in our will. So there is, and that's one of the, and a brother here made a good point is, you know, I should discuss the main and main important factors of a will, and that is one of the main clauses is your funeral arrangements. And in that, I actually have, and myself and Sheikh Mahmoud, we have a clause in there that an autopsy is not to be done on your body, and there's many clauses in there, and we go through them when we draft the will. And of course, the main thing is that your funeral is done according to Islamic tradition. Now, alhamdulillah, a majority of us reside in Edmonton, and you know the Al-Rashid will take care of that. But you never know where you're going to pass away. You can pass away up north at Fort McMurray. You can pass away in another city. You need to make sure that in your will it's stated your funeral is going to be according to Islamic tradition.
Okay, bismillah.
If it does not say it on the will, can you add a statement attached to the will saying that it and it's followed by the law?
So the question is, if it's not stated in the will, can you add it into the will after it's signed? So if the will is done by me, it's going to be stated in the will. So I can't really comment on that. If you're doing the will on your own, you know, you need to make sure that you state the proper clauses, of course. So I can't really answer that question, right?
So there is a question on Facebook as well, and I think Brother Muhammad answered, but a couple times repeating it. Should the appointed person be a Canadian resident who resides in Canada?
Yes. So should the appointed person, and again, I'm guessing that's the personal representative of this. So the person that executes your will. So yes, he should be in Canada. You don't